Hello, everyone. Thank you for joining us for another episode of Practical Law. My name is Troy Tyson. I'm an attorney practicing in the state of Indiana. As always, this episode is not going to constitute legal advice, and nor does it establish any type of attorney-client relationship. Just want to provide you with some general legal information to help you with some of the issues that you might deal with on a daily basis or have questions about. One of the things I want to talk about today that I get a lot of questions about is I'm representing myself. How can I prepare to do that? What's the best way to kind of handle my case in court if I've decided to go at it myself? There's an old adage, which you've probably heard, which is the person who represents themselves has a fool for a client. And there's some truth to that. Sometimes it's I'd say most of the time, it's far better to have professional representation. If you've got a legal matter, these issues that you're dealing with in the legal context are typically very complex. They have a lot of procedural rules, a lot of deadlines, a lot of legal concepts that really just aren't easily accessible to the layperson. And so for those reasons, having representation is usually in your best interest. However, there are some people who, for whatever reason, just want to go at it on their own. There are some smaller types of cases, maybe if you're in small claims court, for instance, if you're a landlord, things like that, where the rules aren't as arcane and, the procedures aren't as complex, where you can kind of figure things out if you're willing to do your homework. Sometimes in family court, you have people who choose to, represent themselves because they're passionate about their children or passionate about their case. Sometimes it's just a matter of financial means. You just don't have the means, the resources to hire a good attorney, and you're kind of left in a situation where you have to go at it, kind of by yourself. So, kind of want to walk you through maybe some general ideas of things you want to think about if you're going to do that. So, the first thing is to know your case inside and out. And I know that may seem, kind of basic or obvious, but it's really not. You'd be surprised at how many people go into court and don't really know the details of their case to the extent that they should, right? Know every detail of your case, both your side and the opposing party side. Make an outline, detailing kind of the major issues, pros and cons, the strong points of your case, the weak points of your case, strong points of your opponent's case. Have that ready and have those details ready. I can promise you, when you get into court, for whatever reason it is, if it's small claims, if it's family, if it's civil, whatever, the judge is not going to know your case nearly as well as you do, if the judge knows it at all. Okay, so it's your job to educate the judge, your job to know your case inside and out. That's number one. Number two, have a plan, have a narrative, have an outline, a structure as to how you want to present your case. Once you know the details of your case, what's your story? What's the narrative that you're going to try and present to the judge? So, it's not just enough to say, the father has only exercised custody, 3 times or exercised parenting time 3 times in the past 3 months. That's fine. That's a fact, right? That goes in your outline in terms of you knowing your case and knowing what days he came and got your child and how long he spent with them and the circumstances. Those are facts. The narrative is, you have a dad who's just not engaged with the child, right? That's the broader story that you would want to present to the judge in that case. A father is not engaged. He's not engaged with his daughter, and therefore, judge, I want you to take this, and that step, right? So that's the difference between a narrative and facts, and you need both. You want to have those facts, but you also want to have a story that you're presenting to the judge to help him or her understand kind of the story in a palatable way. The third thing is you really want to have your exhibits ready. And I will tell you, I don't go up against pro se litigants very often, but when I do, this is the one thing that's their biggest weakness, is that they don't prepare their exhibits properly. Okay, your exhibits are going to be the evidentiary documents, recordings, things like that you're going to introduce to the judge to help him or her decide in your favor. Okay, it's basically the documents that are going to support your facts. And, time and time again, I come upon pro se litigants when I do encounter them who just, their exhibits are not properly formatted. They're not printed well. They don't have copies. You need copies both for yourself, for the court, and for the opposing party They're not labeled properly. So take some time, do some digging online, maybe get some templates off of the internet, of some ideas of how you can structure your exhibits, have your copies ready to go, make sure they're neat, make sure they're legible. That is going to make a big impression on the court. And the flip side of that is if you don't have your exhibits properly prepared, they could very easily be excluded from evidence. And so the documentation, the recordings, things like that are going to prove your case for you may be excluded altogether if you don't put them together properly. Okay, so the fourth thing is know the procedure. And I know I said earlier, the procedure can be very complex. It's usually not suited for a layperson, but the law in most states, certainly the law in Indiana, it's probably the law in your state, is that if you choose to represent yourself, you're held to the same standard as an attorney. Okay, that means you got to know the laws of evidence, the rules of evidence. You got to know the laws pertaining to your case. You need to know the local court rules, which can be very specific. So if you're going to take on this step, do your homework and know those rules to the best of your ability. You're not going to get a JD, a law degree, in the 3 weeks preparing for your case, obviously. Okay, but you need to be as educated as possible about the rules and the procedures so that you can be best prepared and, again, build credibility with the court so that the court can see you've done your homework, you've done your preparation. Okay, so those are just some general ideas about things that you can do and implement to help you take your case to court if you do have the guts and the gumption to go at it on your own. Those are some of the things that you can implement that will help you in court. If you enjoyed this video, if you enjoy the content, please subscribe. And until then, we'll see you at the next episode.